is Contact Engineer Wycliffe at 0707 476602 and he'll get your house dumped up.
Public participation and involvement in the legislative and other business of parliament and committees. So that let us say what happened when the Senate conducted business without
If you're here for the first time, please go and hit the subscribe button. And if you're watching from a different platform, just head over to YouTube to search for Diblo Fuller. Hit the subscribe button. You're going to be getting a ton of content of this nature. If politics is something you're passionate about, this is definitely the one channel that you really need to subscribe to. Alright guys, adios.
That you are seeking to be is that the impeachment motion lacks the particularization and specificity required by Article 145(1) of the Constitution. This is important because it was submitted by Senior Counsel Ongoya, and he explained in detail how the charges 3, 4, and 5 particulars that were relied upon were in particulars or the charges in A and B, charge 1 and B. So that there were no particulars in support of those other allegations. The next prayer that the petitioner is seeking is as regards the inconsistent and violation of the Constitution B, a declaration that the resolution passed on the 8th of October 2024 by the National Assembly to impeach the petitioner pursuant to the provisions of Article 145 and 150. And the communication dated 8th October 2024, sent by the clerk of the National Assembly to the Senate, titled that are both founded on a process that is inconsistent and in violation of the Constitution of Kenya. The reason why this prayer is being sought, my Lord, from my lady, is for the reason that there were many inequalities resulting to the impeachment process, both at the National Assembly and the Senate. So that
welcome guys to the live. How are you doing?
And whatever that resulted from that particular process.
How are you doing?
The impeachment process. So that we pray that the court can grant prayer number 3 as court in.
It's going to rain.
The Lord will also sought a declaration that for the purpose, a declaration that for the purpose of impeachment for the president or vice president of the Republic of Kenya, adequate public participation.
Welcome to the live. Welcome guys, welcome. It's your host Macklyne from Kenya. How are you doing?
1,450 electoral votes for the presidential election system. Now the background of this is that the election for the deputy president.
It's raining guys, it's raining outside. Hi. Alf. Alf, hi, how are you? Welcome to the live. How are you doing and where are you watching me from? Guys, if you are new here, please consider subscribing to the channel.
So that without a clear communication that public participation was take place in all the 290 electoral constituencies. And
if you are new here, consider subscribing. Also give the live a thumbs up, guys.
Have met the constitutional threshold for meaningful public participation. It is for that reason then, my Lord, we pray that you can find in favor of the first petitioner.
Like the live for me. Where are you watching Macklyne from? I'm streaming live from Kenya, East Africa. Streaming live from Kenya, East Africa. want to make dinner
Subsequent to that, my lord,
as early as possible. I hope it won't rain before my daughter comes.
a declaration that the proceeding before the whole
It
house
should wait a little bit for her to come
Kenya and at one
before it
Constitution of
pours.
Kenya are not limited time-bound pending. This is my lord what Ochieng Dudley claims that the pending that the Senate imposed on itself was not did not have it anymore. So that it was not justified for the Senate to impose itself on a 10-day period to conclude the business in a regular manner, as it was dictated by the Speaker of the Senate.
Welcome guys, give the live a thumbs up. Let me know where you're watching me from. It's your host Macklyne from Kenya, East Africa, guys.
Lord, prayer number G is a declaration that the petitioner's right for fair administrative action and Article 47.
It's your host Macklyne from Kenya, East Africa, guys. Welcome to the live. Welcome to the live. Where are you watching me from? Where are you watching Macklyne from? Kindly give the live a thumbs up, guys. Like the live, please. Today, let's reach at least 10. Let's reach 10.
Regardless of that application, to proceed with the impeachment process.
Welcome to the live, guys. Welcome to the live. Where are you watching Macklyne from? If you are new in the house, please give the live a thumbs up and let me know where you are watching me from. Where are you watching me from? Kindly give the live a thumbs up, guys.
Properly assess each of the 25 grounds examined either collectively and individually for gross violation of the Constitution. I explain to you again that even where a provision of the law has been declared unconstitutional,
How are you doing,
the National
people?
Assembly and the Senate still proceeded to find and uphold those particular allegations. The analyses have been explained, and the court has been taken through.
Subscribe to the channel, give the live a thumbs up, let me know where you're watching me from.
But nevertheless, the National Assembly did not consider it necessary to find that some of those allegations were unfounded and could not stand the test of law. Next to that is an order that this was
Please like the live for me, please. Like the live.
I'll not read each and every order, but we have taught a order of statutory to remove and push the communication of 8th of October 2024, 17th of October.
Welcome to the live. How are you doing?
Promoted by impeachment, His Excellency.
And where are you watching me from?
As the Deputy President of the Republic of Kenya. The reason for this, my Lord, is, as explained before, that there were legal illegalities that were committed along the way, and these particular notices of 8th of October and 17th of October were the culmination of those particular illegal proceedings. So that the only
Like the live. Give the live a thumbs up, guys. Give the live a thumbs up. And let me know where you're watching me from. Where are you watching Macklyne from, guys? How are you doing? Where are you watching me from? If you are new in the live, please give the live a thumbs up and consider subscribing to the channel, please.
Lord, we have then all the other prayers that we have fought. And Lord, by the time someone is being elected to the office of the deputy president or any other office, the expectation that comes with it. We have given an authority that this court can award damages where there are violations of the Constitution. This is the case of Manyara versus Republic, where the court held that where there are violations of the Constitution, and this is after the graph, 151 of the Commission, Lord, you have a chance to look at it. The case of Manyara and two others, the AG 2016 East Kenya report, that where the court says that award of damages for constitutional violation of an individual right by states or governments are released under public law remedies within the discretion of the court. So that as paragraph 4 of our prayers. The first petitioner has come before you and is praying for general damages, punitive and aggravated damage. These are not perfect because the court has previously found that they are awardable by the court, because if we have demonstrated to the court that his rights were violated, then the court can award damages as paid under paragraph 4.1 of our submission. But we have also explained the detail that he was earning a salary that maybe I don't have to give a figure because there's a lot of calculations, mathematical calculations. But if you have a look at paragraph 4, where we have listed the benefits that the deputy president was earning, what he was entitled to, and what his salary could have been if he worked for 5 years, that the Kenyan people had given him a money. So that we have therefore calculated those particular salary expectations and benefits that he was entitled to under the law. And we pray that the court can allow and award those particular areas as sought. My Lord, the office of the Deputy President attracts some benefits, again, other than the salary, which you have enumerated under paragraph C, because there are quite a number, including quite a number of issues, cleaners, gardeners, and all that. I believe that my Lord, they will have a chance to look at those particular prayers and the allowances that he could have been entitled to. Could he have served his full 5-year term?
So here is my cabbage. I want to grate the carrot. What is carrot? Mix everything together.
One by one, and the whole thing is allow the petition as prayed. I think Abishari will have a word about it.
I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called cost. We need cost on behalf of the deputy president for all the bad things that have been done to him and to us. The last particular highlight on behalf of the first petition. Thank you. I see the director standing up. You said you left in 2 hours. Huh?
Like the live, guys. Give the live a thumbs up. Let me know where you're watching me from.
Who else is here to speak?
My name is Nancy Onyeka, hosted Tomato and Company Advocates Kilgora.
In terms of equality of arms, I am concerned that the petitioners having had 5 hours and the other party having the possibility of taking another 1 hour, 2 hours, then mean the respondent then have, in terms of equality of arms, they then need the same amount of time in responding. And you have given 6 hours previously, so perhaps I suggest that I come together report of together with the other petitioners, then share the 1 hour so that we are
Yeah.
so that we don't go outside the 6 hours. Test can take 20 minutes. So that we
Why are you so
I think my learned friend, Professor Paul is being anticipatory. Let him wait and see perhaps how long it will take. Then he can say at that time how much time he wants, rather than trying to put a coat in some straight jacket. We are very grateful those appearing for the first respondent, but I do plead that the other council appearing for the other petitioners have their day court.
We are in court.
Yes,
We are in court. They are having their day.
they have their day in court.
Yes.
Because what this honorable court will ultimately say either is going to apply.
I think the only issue we need to address is how much time we need, and I think we should accept that we don't have all the time. So let us plan to share maximum of 1.5 hours.
Your Lordship, I'm sorry, but I'm constrained to object to that approach. When we had the hearing for the confirmatory order, we restrained ourselves and took our and allowed the court to limit our time.
Yeah.
For the petition, let us have sufficient time to vetting on all the issues. We can take the least amount of time possible.
How does it look like?
October is coming up. I don't know how much time you have to.
For the rest of the things we are wasting time, let's proceed. We will see how far we go.
Good afternoon, Your Lordship, Your Ladyship. I appear alongside my brother, Mr. Sakinta. We appear on behalf of the fourth to the eighth petitioners. As the issue, we will be relying on the following documents. We will be relying on the petition dated 18th October 2024. The affidavit in support sworn on 18th October. The written submissions dated 16th January 2026. The list of authorities dated 16th January 2026. The further list of
Guys, tell me, how are you doing today, people?
April 2026.
How are you doing today?
All power has limits. All power has limits. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stones of this democracy, they must be observed scrupulously. If these values are not observed and their precepts are not carried out conscientiously, we have a recipe for constitutional crisis of great magnitude. In a state that is predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That is a paragraph from Nyati, which is a member of the Executive Council for the Department of Health, Gauteng, and another 2008. Madala J, at paragraph 80. It's in our list of authorities supplied dated the 5th of April 2026. My good friend, Elisha Ngoya, wandered in the morning, and I joined him in the wandering. Which way, Kenya? What is the state of our morality?
Business base, not this. I like this. I like that person.
We have provided a case, and
Endless
that case will form my next line of submission, a case of PSF, Economic Freedom Fighters versus National Assembly, 2018 South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state. in terms of the health of the democracy that we have in this country called Kenya. This is a crowbar in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by a huge cost to the ordinary Kenyans. People shed blood, people were killed, people died. We should not lose focus on that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings
I will be
to
there.
be established before the process commences? Did we need specialized rules and procedures before the process of impeachment investigation and hearings commence? That is a question the Lordship, the Ladyship, this court must answer. And like my elder senior counsel, Elisha Ngoya, I'm relishing to read the answer to that question for this. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionality and the rule. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Costly. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge, short-term political gain. Number three, guarantees of fairness and due process. Office holder facing impeachment serves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number four, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures institutional consistency. Preset rules prevent changing procedures mid-process to suit the circumstances of the person under investigation. We are giving you the 10 days, then midstream, we are going to continue irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. Promote separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for us we know, perhaps we have dissenters who are willing to vote against the impeachment.
Is it too late to learn to listen? Too late to be less a man. How would it
We had objective evidentiary standards from the court
Hi, DJ Mark. How are you?
in Parliament. That we don't know. But if that was agreed to in terms of rules, we will know what we are facing in terms of what evidentiary standards are we going to abide with. Finally, it builds a stable constitutional precedent. A predictable framework helps future impeachment processes remain consistent, credible, and less destabilizing governance. A stable constitutional precedent can only emerge where constitutional values are treated as binding rules rather than aspirational rhetoric. The foundational values of the Constitution are understood as enforceable obligations. They naturally demand structured, predictable procedures whenever the most serious constitutional powers, such as impeachment.
I'm doing good, and you?
In this way, fidelity
How are you doing, and where are you watching me from?
become the anchor for consistency, ensuring that future impeachment processes are guided by principle instead of political expediency, and that governance remains stable, credible, and firmly rooted in the rule of law.
I'm doing good, and you?
Four, a rule-based
How are you doing?
impeachment process. There are no rules. In terms of the constitutional values at play, this court is going to make a decision for expediency. This is not just any other
You're watching
decision.
me from the Caribbean.
Constitutional values
Thank you
are
so
not
much.
relative.
Thank you so much. I'm streaming live from Kenya, East Africa.
They are binding.
Streaming live from Kenya, East Africa. How is Caribbean?
Our pillar stones. And these values that we have in the Constitution, such as the rule of law, due process, constitutionalism, accountability, transparency, separation of powers, are a must. They are inextricable. So when impeachment procedures occur without procedural law, clear procedural law,
How is
Parliament is
Caribbean?
no longer implementing the Constitution. It is operating outside it. And I dare confidently, with all the strength from my ancestors from Nyahera and Kisumu, say this, that impeachment is not a political ritual. It is a constitutional trial. May I repeat this for members of the National Assembly? My senator from Kisumu is here. Impeachment is not a political ritual. It is a constitutional trial.
Can
So
you
without
describe
procedure, the process
yourself
becomes
in
arbitrary
3 words?
and this directly undermines constitutional supremacy. That is one.
Wow, me.
Number two, the rule of law requires procedure.
You want to describe myself in 3 words? I'm
The
caring,
rule of law means that power
loving but not forgiving.
through known,
Caring, loving but not forgiving. It's hard for me to forgive. Even if I say I've forgiven you, I'll keep it inside my heart. I won't forgive easily.
That is rule by man, not rule of law.
Though I do care, I'm a loving person, but once you cross my path, I'm forgiving. I don't forgive it easily. I am unforgiving.
If at all it existed, kept on being a moving target.
Unforgiving.
There was no right of defense. It was never guaranteed in the first place. People wanted to finish with what they wanted to do and move on. There are no clarity in terms of timelines, fairness, or impartiality. This creates a dangerous precedent where decisions depend on political discretion, not law. The process becomes rule by numbers
God said that you have to forgive. Yes, but some people take advantage of that.
Absence of procedure means
Some people do take advantage of that.
absence of procedure means absence of legality. Number 3, impeachment is a quasi-judicial process, not a political vote. That term quasi-judicial has been used a lot here. But what is exactly meant by quasi-judicial? In my other life, I'm a member of the academy, and I see two senior members of the academy here. They can confirm that, and may God bless them in advance. Professor Jenda, Professor Gideon Mugai, senior members of the academy. Quasi-judicial power means that this is the power to determine disputes or making findings affecting the rights of individuals, similar to the way courts operate. What was at stake during the impeachment? A validly elected president of the deputy president of the republic was going to be impeached. His rights personally and the rights of his many supporters, those who voted for him as part of a ticket, were going to be affected. The consequences are there in terms of the quasi-judicial power. The removal of a deputy president being a very serious constitutional action. It has consequences for the electoral will, the millions of voters, stability of the executive, continuity of government. And because of this gravity, impeachment must meet quasi-judicial standards. Quasi-judicial standards, these are the principles of good governance. I don't want to go through the whole list, but again, members of the academy, Professor Don Oliver has reduced the principles of good governance into 4. Very quickly, these are legality, procedural propriety, rationality, and proportionality.
Yes, God says to forgive, but some people do take advantage of that, which is not good and it's not correct in any way.
Retires, we pray that you are going to consider those 4 principles. This process, as has been brought up by the first petition, do they meet the test of legality? Do they meet procedural propriety in whatever guise? Does it mean rationality? Again, Professor Jenda should be familiar with Wellesbury degree, rationality. That's a test.
Also address the court,
God says that you have to forgive.
Most of life. If I've been to the academy, please forgive me. Most of the time, I veer towards the academy. Wellesbury rationality.
Guys, if you're watching the live, please give it a thumbs up. And let me know where you are watching Macklyne from.
Impeachment process. Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion Committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Witte submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, But constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in a manner to conducted in this case, the electorate's choice can be overturned by unregulated political process. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects the protections for the individual, the real protected target is the core principle of popular sovereignty. 5. The absence of procedure invites a constitutional crisis. Why? Because without procedure, courts are forced to intervene. Parliament claim political privilege. The legitimacy becomes contested. We have a deputy
So I'm cooking dinner.
Gandhi versus Union of India, 1978. And it
Please
presents
God, don't let it rain now before my daughter reaches home.
the Supreme Court of India
I
interpreting
beg in the name of God.
of the Indian Constitution. Due process in this manner. It says, number one, that procedure and the capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment, and you are satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democracy, democratic institutions and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark. I submit. I'd rather Sakinfa joins in next. Thank you.
The Lordship and my lady, my name is George Sakifa. We do appear together with Mr. Ogada for the 4th to 8th petition. Your Lordship, the petition that is before you is originally the Uruguay petition 3015, and this has been consolidated with this petition. So, Your Lordship, I will only deal with two issues because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle two issues. The first one being on the element of public participation, and this is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently explained here, especially the DAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of VAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in this short submission is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Muni Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed, and that is what he has detailed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient, and therefore ordered for a second phase of public participation. So, Your Lordship, what in the National Assembly did, instead of going back and preparing for a proper public participation, as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavit that was sworn by the by the 5th, 6th, 7th, and 8th petitioners, Your Lordship, they do confirm that they came to realize that the extension was given after it, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is a humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where of course the court in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relation. It is not a mere formality to be undertaken as a matter of course, just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointment Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the presidential...
Oreos, hi Oreo, how are you? Welcome to the live. How are you doing?
With the provision of...
How are you doing?
Except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of is compliant substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So an appointment under this constitution, Section 3, an appointment under this constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority, in this case was the President, so after appointing Professor Kibore Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complies completely in all aspects to this Act based for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this presidential memorandum of nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this presidential memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following documents, and which the senior counsel Paul Witter said that it was done in an ungodly speed. So, Your Lordship, I want to reiterate that the essence of this Act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6 for approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President...
It's like it's going to rain.
So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further said, in forwarding this nomination, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the President arises. So, Your Lordship, within 14 days, of course, this was done within a few hours. The impeachment was done at night, and in the morning, the President did this act. So the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave 60 days for Parliament to consider the appointment of the new nominee. And the reasoning, Your Lordship, is that these documentations that have been given.
My favorite thing is cooking. I love cooking.
Parliament was under an obligation to consider.
I enjoy cooking a lot.
Your Lordship, by midday,
And you?
on
What's
18th
your
of
favorite?
October, Parliament has already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6.4 that required the public was to be given at least 7 days so that they can give their issues in terms
I
of
love
the
cooking a
ability
lot.
of the deputy president nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National
I love
Assembly
cooking
in their
ugali.
resolution,
What do you
they
like
have
to
filed,
cook? I love
or rather
cooking
they have
ugali.
given a ridiculous response to this.
Oh, you like
this
DJing.
submission that we
Me,
made.
I love cooking ugali, chapati,
They say that
pilau,
this was a sui
tea,
generis,
everything.
it was a sui generis procedure. The
Everything.
effect that it was not an approval but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing. Your Lordship, then the provisions of Article 118.
Like right now, I want to go and cook.
Because they will still need.
I'm already taken. I'm out of market. In fact, right now I'm waiting for my daughter to come from school and my hubby to come from work.
The public access and participation. So it says that Parliament.
I'm already out of market.
Participation and involvement in the legislative and
I'm out of market.
So, Your Lordship, even if they escape the provisions of Section 6.4 of this act, of the Public Appointments and Approval Act, then they cannot circumvent the provisions of Article 118, which requires that Parliament must still, in all its businesses, involve the people. And Your Lordship, there is an authority that I want to rely on, and that is the Legal Advice Center and two others. It is in our case, in our bundle of authorities, versus the county government of Mombasa and four others. It's associating with issues. And Your Lordship, I just want to quote in verbatim a very small part where the court says that the purpose of committing public participation in the law-making process is to afford the public an opportunity to influence the decisions of the lawmakers. So, Your Lordship, assuming that you are to take the proposal that they say that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the deputy president nominee. And the Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the Speaker is elected. They are directly elected by the members of Parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. The Lordship, our submission is that it was not often in law for the Senate to take the approach of the plenary. And my learned friend will tell that we have already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if you were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize section 27.1, that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, the Lordship, under Article 27, there is a benefit that has been, under Article 145.3, there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a rule that is provided here, it will actually amount to a discriminatory act in the following sense, my lord.
I love cooking.
It means that the Senate will be deciding. There is no criteria as to when the special committee will be applied to the Senate, and when the plenary will be applied to the Senate. And Your Lordship, what that means is that
Guys, if you're watching the live, please give it a thumbs up and let me know you're watching me from. Give the live a thumbs up, please. Please like the live, guys, if you are watching. Please like the live if you are watching. Don't just watch, also like. Yes. Amekuja. Unajua kufungua gate? Namwambia atufunge pia. Umechelewa ni 5. 5. Can you imagine 5? You are supposed to mom. How was your day? Lakini viatu za shule zinakufinya. Hiyo sasa umenionea. Hizo ndio unavaanga, si zile zingine ndogo. Ani nafikiri zile ndogo. Hapana, si zile ndogo. Hizi ni zile kubwa. Sawa. Moja ama mbili. Hata wewe unataka kiatu namba. Ndakubaia kiatu namba. Ukienda kucheza nje, uleta marafiki zako pamoja. Na uchukue soksi zingine uvae. Juice iko kwa meza, ukinywe juice hakuna mkate, kuna nduma na kuna grapes. Sawa? Nasmailia nani? My green grams are ready. So this one is done. I want to make rice. But before that, I have to soak the rice before I start cooking. Juice ni baridi, utakunywa chai? Ndaka tu juice. Umepewa homework? Na uliacha chai ikaharibika lazima. Wewe basi si ukunywange tu uji ya shule tafadhali. Mara umekunja portfolio. Nani umekunja portfolio? Uji. Utasema je kusoma?
Sema tunaanza kwanza
Oh, kurevise. Wacha kukunja sawa? Kunywa juice na fruits. Ndio uende ucheze sawa? Na ball. Umerudi nayo kwa nini? Si ulikuwa wachie ticha shule. Kila kitu iko tu hapa ndani. Nibakie kijiko. What did you take for lunch? Umeboeka? Kwa nini? Siboeke. Mama baada ya kwa hai. Mama kiwa hai mtoto ataitwa kwanza ndakana unatoka kuna kitu. Unacheza. Unasikia? Umetupa tu kofia nini socks nyingine sasa? Nimepata tu socks. So chukua mpaka hii. ile sweta nyingine nikipata utakuja uvae. Alafu wewe ulize marafiki zako socks, sawa? Kama wameiona. Na usijaribu kutoa socks ati unakimbia bila socks. Ndio hizo. Nataka kukimbia bila socks. Kuna baridi nje, wengine wamevaa socks.
Something that is considered to be inappropriate in reference to the deputy president even before the motion was presented before the National Assembly. This, as we said, while they do not vote in an impeachment process,
Hizo clips zilikuwa zako.
it is extremely important that the two individuals who
You are my daughter.
mandate for presiding over the impeachment process ought to have to work with impartiality, and they have
Hiyo thing ilikuwa yangu, si ndio?
no bias.
Nikupe nduma.
They have to say that the two of
Cookies.
them failed.
Na tule tumevunjika. Yenye nikataa asubuhi. Hizi nifungwa na sijui kwa nini ulikuwa unakata. Ulikuwa nafikiri ni tudogo. Si tudogo. Haya.
The Hansard is in reference to the impeachment proceedings. I believe it should be before, without it before this vote would mean that I'm not able to point out the specific date, but it should be before the court. The one for the National Assembly. I make reference to the one for the National Assembly. 5th of October 2024. Sorry, Your Worship, 8th of October 2024. In that particular Hansard at page 18, I picked the remarks that were made by the member of parliament for Sumba South, Corona Mondi. At page 34, I picked remarks that were made, these were made by Honorable Captain Omani. And also, so I read the two of them. So they went ahead and introduced other issues. Also, I forgot
Latina. Na ukimaliza kukula, kucheza, unakuja kama umeingia kwa bafu. Haya.
I will not go into what they said, but I'll ask the court to look at some of the issues they said, which to me were personal issues they had with the deputy president, or some long-held grudges, which they used as their reasons for endorsing the advancement of the impeachment to the Senate. This being an impeachment trial, which, as we said, in the set in the Wamara case, which requires a very high standard, and the Constitution, which also talks about grossness and seriousness of the misconduct of the violation. You cannot introduce any other ground, even if that's what is your reason. You have to debate, you have to vote on the impeachment on the basis of the grounds that have been stated in the motion. So that is another failure which, on that basis, I would ask the court to find that the impeachment failed to meet the standard, the constitutional standard. It doesn't the constitutional standard and threshold, and therefore it ought to be declared null and void. The
mechanisms, or rather legislation, to operationalize Article 150, in this case, of course, which incorporates Article, the other articles of impeachment. Again, on this issue, I did make a presentation in the BBI case on the lack of legislation. In that particular case, the issue was lack of legislation for collection of signatures, and that was an important issue in the BBI case. And the court agreed, and I would ask this court to make that finding, which is extremely important, that this kind of a process, being so important, must have legislation. And I would like to state why it is important. For instance, when you look at the provisions touching on the election of a president and a deputy president, it's very clear provided on the judicial review available to any party who is dissatisfied with the process. It's elaborate. It has to be that you come before the court, you raise your issues, the court makes a decision. Thereafter, then whoever is elected is sworn into office. So the constitution, in a way, has actually enforced some conservative relief. However, that is not provided on the issue of impeachment. And therefore, just as important as the process of occupation of that office, so should be the process of keeping that office. And that, therefore, would require legislation to address that issue. We were before this court, we argued the issue of conservative order. Your Worship, it leaves us in a difficult position.
Nimekumbuka mwingine bedie alikuwa amekuja kwa geti. Sasa anafikiria wakina nani ndio wako hapo ndio wakina Maxi. Akarusha ufunguo. Kumbe sio wakina Maxi. Na Moha atisa anajifanya anafungua na afikiri. Sasa alinipigia na niambia kwani mfungui. Nikamuuliza umwambia nani afungue. Niambia kuna kulikuwa na mtu nikamwambia sina Mohaji alikuwa anafungua na afikiri huko tu. Enda ucheze mama. Utaki kucheza? Basi wengine wanacheza.
Tarehe imeisha.
siwezi rudia hiyo tabia. Mama, mbona unafanya hivi? Nakupea kuki na unarudisha. For lunch. Tungekuja hata na mkate. Unajua kwa nyumba uliacha bila mkate.
Haya wala kusikia na penduka hivi kamera.
Nitaendea.
Na mimi nataendea.
Hapana, siende wapi.
Hebu ngoja. Abuda, how are you? What is the time in your place? Lavina, ni saa ngapi hapo? It's 5:53 p.m. In Kenya, East Africa, it's 5:53 p.m. Where are you watching me from? Where are you watching Macklyne from? Hello, Abuda. Hello. How are you doing? Welcome to the live. Here in Kenya, it's 5:57 now. How are you doing? Mom, niweke hii hapo nje kwa nini kwa hiyo dustbin tu, weke tu hivi. Shika mama. Nilikuwa nimeweka maji ndani, maji moto. Napika chakula mingi ndio gasi ikiisha. Chemsha tu kwa microwave. Nataka nini? Si ni ukweli gasi ukiangalia mtungi hakuna kitu.
Maliza.
Bado. Fungue iko wapi?
Takuja hapa.
Fungue iko.
Unaleta mimi na nini? Mkate tu peke yake. So nitafutilia kasabuni kadogo. Sabuni ya unga. Lavini hebu nyamaza kwanza. Sabuni ndogo ya unga. Sabuni kadogo ya unga. Au pesa itaingia usiku. Mali to come. Oh, we. Cooking rice. Heat the rice. I've washed. people, welcome to the live. It's your host here, Macklyne. Very tired. I was cooking. Let me take my sweat. I'm feeling cold. I'm here, guys. Tell me something good. How are you doing and where you watching me from? Welcome, guys. Welcome to the live. It's your host, Macklyne, from Kenya, East Africa. If you are new here, please consider subscribing so that you can reach 3,000 subscribers. And if you are watching the live, please consider liking. Like the live. Please like the live, guys. Like the live, please. Also consider subscribing if you are new in the house. And your host is Macklyne from Kenya, East Africa. Like the live kindly, guys.
Every case is urgent. We got our case in our criminal today. So when animals need help,
You're getting sleepy.
we just have to get all that nasty wood stuff out. It's officially situation critical in a surgically selected lineup. Saturdays at 6 on 1.
Radio. Energy. Radio.
Thank you for the soap. I
Mbona?
was really waiting for the soap. Ah. Ah. In how much?
You know, 60. Sasa hiyo nitachukua hiyo pesa niweke mafuta supu.
Kwani sikuweka bugatti. Niweke kwa bafu. Eh? Lakini hii mkate inaanguka. Inaanguka ndio inakuja. Ndio hii inakuja tunaiona. Inatembea. Like the live guys, support the channel. Hiyo ni kuku. Biscuit iko na tamu ndani. Na si macha mlango wazi. Kama ni dadi. Shorts zako zimepata views.
Shika.
Shorts zako zimepata views. Hatujaangalia. Ni kuangalia tena.
Asante. Unajua mimi I don't fancy hizo vitu.
Nakuona kama kula chocolate. Kula chocolate.
Wapi?
Hapa.
Sipendi kukula, doesn't mean napenda. Sipendi.
Nakayole kula.
Alafu
Kuelewa ndio utakuelewa.
tunakuongelesha. Umefikisha 12 subscribers. Na ulianza leo. Asubuhi ulikuwa na 3. When uliingia tu before post.
Leo ni wapi?
Tisa, sio yote. Ma, ona picha dada alipost shorts. Na kapata views, ona.
Ma, hiyo ndio breakfast.
Hii ni kitambo. Ona 1.1 views, 1.1k views, 1.2. Ile marago yenye uko imebaki nyuma, imekuja ikapita ya nyumba.
Kwa YouTube. Kunywa chai hicho. Nikakunywa usiku. Nabaki hapa kidogo.
Hey, Jesus Christ. Hata mimi napata pesa leo usiku. Mtu anajikuna hivi.
Naingia mpaka fululizo. Naingia mpaka fululizo.
Si hata mimi. Yenye libai cabbage. Libai cabbage, nyanya za 100, nyanya 10. Na makaa. Nasikia? Na vitunguu 3.
Nyanya na bei zimepanda sana.
20. So kesho kibahatika kuja na maziwa na mkate. Ama ubaye Lavina kitu yenye atabeba Wednesday. Si tunaweza kula Githeri.
Pesa maziwa iko hapa. Maziwa ni 600.
Maybe kuja basi na.
Pesa maziwa iko hapa.
Sasa basi
500.
kesho kibahatika kuja na nini? Na mafuta ndogo ya kupika.
African elephant stands up to 12 feet, and that's just to the shoulder, weighing up to 7 tons, as heavy as a school bus. Its primary weapon, 2 spear-like tusks, grow up to 8 feet. That's only 2 feet short of a basketball hoop. Elephants are practically unstoppable. This pump is stalking its next victim. Not usually aggressive to other species, this rhino female has no cause for alarm. She may have poor eyesight, but she can still smell and hear the pump nearby. He casually pretends he's on a stroll through the bush. The rhino doesn't want any trouble. The pump hits her rear, almost bowling her over. The rhino swipes back. The white rhino weighs in at over 2 tons and has a front horn up to 5 feet long. The horn can be a lethal weapon. Made of keratin, the same as claws and nails, rock solid, anchored deep into her thick hide. Its large neck hub is pure muscle for lifting its heavy head, giving a powerful upward swing. The top keeps coming. The rhino's hair is not attached or grown from bones. It's formed from pure hair that grows continuously from its skin. The pouch slabs into the rhino with a weight equivalent to 2 SUVs. If the pump knocks the rhino over, it could meanwhile, crushing ribs and vital organs. The rhino's body shape gives it a lower center of gravity and good balance, making it harder for the pump to roll her over. The rhino's back makes her escape. The punk isn't done yet. It pursues her. This rhino is no Dumbo. Backs off and takes flight. The only safe option. Leading him to find some of his own stuff.
Lavina, nifungie mlango, mimi nasikia baridi hapa. Na uvae socks ama viatu wewe.
Clashes can be relentless when you're up against your own kind. Springtime. It's been a long winter for this lonely bachelor brown bear. He's working after 7 months. And he hasn't earned.
Leo amerudi saa ngapi? Hawajachelewa?
Kavina. Anasema kuja 5 karibu 30.
Leo amekuja mapema.
Like a graffiti, leaving claw marks in the trees is one way the males can mark their territory. But it hasn't been intended on.
Imagine hii tripod siko anajua inavutwanga hapo juu.
Ndio kazi ile kitu yenye nikataa kurudi.
Kazi gani? Mimi nasema hii.
Ndio nasema kuna kitu ilitoka mahali. Au umesahau?
Iko wapi kitu yenyewe?
Kuna kashimo kako mahali hapo. Huko.
Yeah,
Kazi yake. Ukishapandisha juu kuna kazi hairudi.
na kazi. Na hii si iko juu na iko. Sijarudi na kuna hiyo
Bado ni ngumu. Hiyo kitu hata niliona mkoma naweza tafuta nyingine huko kwa garage. Bolt tu yenye natoshana na hiyo but tafuta mrefu ichome kwa hiyo. Kisha naweza fanywa kwa watu. Nyumbani ndio kulikuwa shida huku. Hawezi kosa.
Hiyo simu ya Lavina si meja. Okay. Rigathi Gachagua anataka full time payment.
Ofisi illegal. Wanasema illegal.
During hibernation, males release up to 30% of their body fat, meaning less protection from claws and teeth. The lonely bachelor comes back with a well-placed left arm. A bite to the face. Pushes off a large, disgruntled buffalo. The buffalo is 4 times the weight of any other lion. But for now, all
Greetings, people. Greetings. How are you doing? This is Macklyne from Kenya, East Africa. I'm in the
The buffalo in the front line of attack of this fight. Horns in tip-top fighting condition. With up to 1,000 in the herd, the overwhelming numbers could spell a bloody revenge. A male makes a hasty exit. You may have the experience to know what's coming. Fewer numbers gather the remaining females. Except one. The bold lioness takes refuge. It's a bad call. The buffaloes surround the rock. It's a siege. A lion's roar can be heard for miles across the savannah, but her pride has made for the hills. Time is on the side of the herd.
You might have feel that man.
A second wave comes in.
Sini mimi.
The bold lioness now uses certain disempower.
Kwani hujai niona? Basi nione sai.